All right. Well, welcome everyone. This is Andy Yost with the Capacity Building Center for Courts, and I also have Scott Trowbridge with the Center for Courts. Scott, you want to say hi?
Hello. How are you?
So today we are hosting our November ICWA meetup. So we have a couple things that we're going to work through today. We have a slightly different structure that we're going to try out, and we'll kind of see how it goes. One of our creators from last month may or may not be able to join us today. So if she can't, it's okay. I got a backup plan, but we'll see if she is able to find her way in and carve out some time to join us. So anyway, just as by way of review, kind of a quick reminder, everybody knows by now, I think, what you're looking at. But just in case you're brand new, none of those names look new to me. We're in an Adobe Connect room. There's a slide deck in front of you, an agenda in the lower left-hand corner. The numbers in brackets are the number of minutes, maximum number of minutes we have for each one of those sections. If we get done a little bit early, that's fine too. In the bottom middle of your screen, you'll see a chat box. Scott and I have both said a couple things, so feel free to type into the chat. Know that the chat transcript is saved, but if you have private chats with folks, no one else will see those and they're not saved. In the upper right-hand corner of your screen, you'll see an attendees list. You can just hover over someone's name with your cursor, and it'll give you a little pop-up box with the option to start a private chat with them. And then down in the chat box in the middle, you'll see a little tab with their name on it. And that'll be the private chat that you can have if you want. And then in the bottom right-hand corner, we have our resource exchange, where each month when we get together and sort of do some peer-to-peer sharing, resources, information, tools, a lot of good material kind of floats to the top, and then we just post it immediately in the resource exchange. So like always, I would invite anyone that has a genius idea or epiphany during the call and thinks, oh, hey, boy, everybody's got to see this resource that we have. Just go ahead and shoot it to Scott via email. And Scott, if you don't mind, can you just type your email into the chat box? I know I have it posted in the lunchroom too, but if it's in the chat box, then we can all know that it's in the beginning and just scroll up. So again, if something comes up and you think, hey, we've been working on this exact issue and we got a great tool or resource that could help out the community, just shoot it via email as an attachment to Scott, and we'll upload it in the resource exchange live so that everyone can have access to it. So that's what you're looking at. Last thing is, from time to time, the screen will move around, which is intentional. That's Scott and I on the back end kind of moving things around in anticipation of where we're headed as a group. So, oops, sorry, I just had a little glitch on my computer here. So know that that's intentional, and that when things are moving around, it's not your computer, it's ours. And that's, you're not going to have a crash. I had a friend who just had a computer crash recently, and what a nightmare. All right, so what we'll do now is we'll kind of just check everybody's pulse and make sure you're not in a tryptophan coma post-Thanksgiving with this simple question that we'll type into the chat. So what I want you to do is type it in the chat, your response to this question. The question is, which one of you brave souls went shopping on Black Friday? And if you went shopping on Black Friday, did you get a great deal? Just type your answer into the chat here. Make sure everybody's got the functionality they need. Yeah, me neither, Amy. I'm still waiting for the moment where I can sit on my couch, order stuff from Amazon, and the drone drops it off on my front porch. Oh, Edie, I hope you got some wrist guards for your 6-year-old too. I used to be a pretty impressive rollerblader back in my day, actually, before I got old and my joints gave up. Just a couple more folks typing in. That's good. I realize it's kind of just a serious, fun question, but I want to make sure that everyone has, importantly, that everyone understands the chat functionality, because there's concurrent conversations. Actually, there's at least 3 conversations that can happen at the same time during these meetups. One is live in the chat, one is over the phone, and then one is also on the side chats. So anyway, just want to make sure that the functionality works there. All right, great. So last time we got together, we started working. Well, we didn't start. We continued to work through a number of things. We've been working on and off for the last few months the ICWA regulations. We had a couple meetups where we talked about implementing the regulations, like sort of what efforts we could take in order to promote ICWA regulations implementation. And we also had some conversations about the substance of the regulations themselves, they actually add a lot to clarify some of the more vague terms of ICWA. And so we've really been working on those. Last time, if you'll recall, we had Yvonne Zare from Illinois who talked to us about Illinois' process of implementing the regulations by hosting what essentially was a work group, kind of a nuts and bolts, roll your sleeves up kind of work group where folks got together and just went point by point through the regulations and then drafted court orders that reflected the regulations. From that conversation, we had some specific substantive questions emerge from the group around notice and inquiry, and around what constitutes a proceeding, at what point does a proceeding start and stop. And the reason why that's important is because depending on whether or not you're in I'm doing air quotes right now, you can't see that, but if you're in a proceeding, certain ICWA provisions are triggered, and so navigating the nuances of the regulations and the statute was a substantive question that emerged. Now, what we're going to do is we're going to try to tackle those three questions today. We'll troubleshoot those three questions. Maybe we'll walk away with some substantive answers. I think there are some out there. I was doing a little bit of research myself yesterday. I know Scott's kind of our resident expert on the regs, but not the only one. There are a number of people on the call that have expertise in this area. So the idea is that through peer-to-peer sharing environment, we can answer some of those questions and tease out the substantive components of the law that we have questions about. So that's sort of what we're going to spend our time doing. One other thing that I want you to pay attention to, though, because I'm going to ask you for feedback on it at the end of the meetup, is what you think about the structure. So normally what we do is we have a creator present an issue, we have some immediate peer-to-peer sharing, and then we move into the lunchroom and we have sort of 4 or 5 things going on at the same time, and then we back out, have an open space, and close. So we're going to do something slightly different this time, but not totally crazy and different. So I'm gonna ask you how that feels at the end and whether or not that was a useful structure. So for those of you that know me, I like to tinker with stuff. You're probably not surprised. For those of you that don't, that's a chance to get to know me, I guess. So, all right. So without further ado, what we'll do is we'll pop onto the first question. So you should have just seen your screen move around. You'll have on the upper left-hand corner of your screen the regulations, and I've kind of zoomed into 23.107, which is a specific question that came up from Ann Gilmore on our last call. And I think Ann was going to join in, but I don't think that she has yet. But I have spoken with her via email about this question, and so what we wanted to try to do is troubleshoot it as a group. So in the upper left-hand corner, you'll see the regulations. In the upper right-hand corner, I've written Ann's question, and you'll notice, hopefully it's okay to read, each one of the questions, there are 3 of them, are written in a different color, just visually so we can distinguish between them. This first question from Ann is with regard to inquiry. She asked this: 23.107 of the regulations requires that ICWA inquiry be done at the commencement of each proceeding. And then she sort of gives like a shorthand hypo here. So you ask all parties and parents at the initiation of the case when a child is first detained, which would be the beginning of the, quote, foster care proceeding, and everyone says no, there's no Indian ancestry. So in other words, you do your initial inquiry as to the heritage of the child to determine whether or not the child, or to try to ferret out information so the court can determine whether or not the child is an Indian child pursuant to the act. In her hypo, you have no reason to know that the child is an Indian child, or no reason to believe that the child may be an Indian child. And so the court makes a finding that ICWA doesn't apply. The case moves on, moves forward on that basis. And a year later, reunification services are terminated. We move toward permanency, which is the start of a TPR proceeding. And as we all know, TPR implicates the inquiry provision again. At that point, the parents say, oh, yeah, maybe I do have native ancestry. The question is, are there no consequences for the delay in bringing this up? So what I'll do is I'll first set the timer for 90 seconds, and I'll just give people a second to kind of digest the question. You don't have to answer anything. You don't have to type anything in the chat unless you have immediate thoughts that you'd like to share. But I want to just give folks, 90 seconds to think it through. If you have the question down, you can also review the regulations on the left-hand side of your screen. So I'm going to set the timer now. Ready, set, go. Okay, that's been 90 seconds. I just started to line up a few of the specific questions that we might ask ourselves about this. But let's just start from the top. If you have a thought as to how you would answer this question based on the regulations or your knowledge of ICWA, what I'm going to ask you to do is either raise your hand using an icon on the top of your screen. You'll see there's like a little person with their hand up in the air. Just click on that and I'll see that you raised your hand. Or you can just type directly into the chat. I see there's a couple folks doing that as we speak right now. Or if you're feeling bold, that would be totally fine. Oh, yeah, *6 to unmute. Thanks, Scott. If you're feeling bold and you want to just interrupt me, please do. I'm used to it. And throw out some thoughts here. So the question here is, I guess the fundamental question here is, what, if any, consequences are there for the delay in bringing up evidence of American Indian or Native American heritage? See a couple folks typing in the chat as well. Gotcha. For those of you on the phone, we got some folks active in the chat here, so we're just letting their answers kind of trickle in, or their thoughts kind of trickle in, I should say. You don't have to have answers, by the way. If you'll recall, as people are typing, the model for a community of practice is based off the Xerox mechanics who, you'd be like the master of the XL 5000, but not any other version of the Xerox machine. So when the XL 5000 broke down, you were the resident expert on it. So folks, the Xerox mechanics would all get together and they'd each have their specializations and they'd be able to help troubleshoot each other's problems. So the whole idea of the community of practice itself, it's been developed in organizational theory, but the idea is to do exactly what we're doing. See if we can kind of work through answers together, as opposed to relying on sort of one sage on the stage. So it looks like there's a couple different thoughts coming in here. So first of all, Edie says that there could be serious consequences. If at TPR you discover Native ancestry and ICWA was not complied with from the beginning during the start of the abuse and neglect case, then it could restart your timelines on the underlying abuse and neglect case and significantly delay permanency for the child. Yeah, and you could have to start over on 1522, which is the placement measure, the placement timing rule. Good. Got a couple more coming in. So another, I don't want to overly confuse the issue here, but another question that has come up is what constitutes a proceeding? So in particular, an involuntary child custody proceeding. We know that there's what's sort of colloquially called a shelter hearing or a protection hearing or something like that, the first hearing, that constitutes obviously an involuntary child custody proceeding that implicates ICWA's inquiry provisions. But I know that there's other folks that have asked whether or not it's just the shelter hearing or the TPR that implicates an inquiry requirement, or whether or not the inquiry requirement is triggered at, say, each subsequent hearing. So let's say it's an adjudication or dispo or perhaps even a review hearing. To be curious to hear how folks are addressing that issue in their state. In other words, what are you calling a hearing that would then trigger the inquiry provisions? I'm sorry, a proceeding, I should say, just to stay true to the language. Now, 23.107 is under the subheading pretrial requirements, so presumably that's before adjudication.
This is Scott. Two things I would say that I think support Edie's sentences there are, you have the section on invalidation that, you could say supports that. And the other thing is, I think overall, if you look at the act, it's meant to protect the children, the families, and the tribe. So, from other ways that courts control dockets and, just the concept of somebody sitting on something and it being prejudicial to their case, I think you can make the argument that the parent not giving out this information can't be held against the tribe, who also has a parents patrie, however you pronounce that. I've mostly only seen it written, right to intervention, etc. So that's another reason I think you can support what Edie said.
Great, thanks, Scott. Scott, can you throw in the call-in number into the chat line as well, please? And Gabriella makes a good point here in the chat as well. The know or reason to know language is for the court, right? So the state court has to ask the participants whether or not the participant knows or has reason to know. And yeah, okay. So if they do, if the parent knows or has reason to know, okay, I see what you're saying now, Gabrielle. Sorry, I think I misread your comment. Good, Sandy. So in Virginia, you say you include the finding at every stage of the case, and are you doing that as a matter of best practice, or are you doing that based on a read of the regulations or the statute that you think, like, are you reading it a certain way that says, hey, it needs to happen at every stage?
There we go.
Okay, good. Yes, Sandy, I see what you've written there. I think that's like based on what Edie just said, and the term proceeding itself, that seems to me to be, at the very least, best practice, if not the most legally safe way to interpret the statute and the requirements, the regulations. You really don't have anything to lose in that case. I could tell you myself as having practiced in dependency cases as a children's attorney I think I was probably a broken record, but I was the guy that always, at every hearing, tried to raise the ICWA issue and ask the court to ask everyone whether or not they knew or had reason to know at each proceeding. I realize that can, from a etiquette perspective, might become an annoyance, but I guess our job as attorneys and lawyers and court stakeholders is to comply with the law. So, gotcha. Thanks, Scott, for clearing up the phone number as well.
I'm so sorry about that. This is Ann Gilmore. I had this on my calendar for 11 o'clock my time, not 10 o'clock. I'm so sorry.
Oh, that's okay, Ann. Glad you could join us. Ann, are there any, we've been kind of taking some stabs at this question to think it through. Are there any other ways that you would kind of nuance the question, or maybe just give us anecdotally something that's happened so we could kind of think through in more concrete detail the answer to the question?
Well, I'm sorry if I'm repeating stuff that you guys have already talked about, but it's just in California we treat a child welfare case, or really any case, like it would be the same with a guardianship or any other kind of case that ICWA applies to, as there's one filing and it will proceed through its entire course and be considered one case. And ICWA inquiry and a determination of whether ICWA applies to the case is made at the outset. So we have an obligation of affirmative and continuing inquiry at the outset of a child dependency case. And there's very sort of strict requirements for doing detailed inquiry and sending notice out to, often many, many tribes. And so, and then we in California make a determination of whether ICWA applies based on the responses we get from tribes. If the tribes respond no, then, the child isn't eligible, then those tribes come off the service list. And then if a tribe responds that yes, the child's an Indian child, obviously ICWA applies to the case. But in a lot of cases, tribes will not reply at all. And then there's a provision under California law that says if the tribes haven't responded after 60 days, then the court will review all of the notices that were sent out and the inquiry and make a determination whether ICWA applies to the case. And if the court determines that ICWA does not apply, then that affects the trajectory of the case, for its entire life. And so I think what this issue of there being an entirely new proceeding that triggers entirely new duties of inquiry and notice when we move from a foster care placement, what we would talk of in California as being the reunification phase of the case, and then move into the permanency phase of the case or the termination of parental rights phase of the case. It just seems to really have the potential to upset these cases where everything might have been done right at the outset. If there was an ICWA error, if there was a problem in complying with the requirements of inquiry and notice, then of course, under existing California law, even you would be able to sort of raise that at a later stage. But it seems like we could potentially have these cases where everything is done right at the outset. There's full inquiry and notice. Parents receive, 18 months of services, and then as we move into a different phase of the case or a different proceeding where we're looking at permanency, then potentially we would be, doing inquiry and notice all over again and potentially getting a different outcome at that stage of the proceedings. Even if tribes had failed to respond early, at the initial removal or reunification stage of the case. And that's what is really going to be, I think, the hardest thing for us to sort of fold into California law is in those cases where a tribe got notice and they did not respond, do we still, does that have then no implications or no impact when we move into the termination of parental rights phase of the proceeding? So that's what I'm kind of struggling with and don't know how we would make that work here in California.
Great, thanks, Ann. There's a couple of folks typing into the chat, and of course over the phone line if anyone wants to jump in and share their thoughts, that'd be helpful as well. While people are thinking it through, I just want to share Sherry's point about this distinction between a hearing and a proceeding. Referencing the definition of a proceeding, she says that the regs say that child custody proceeding means any action that may culminate in a foster care placement, TPR, pre-adoptive placement, or adoptive placement. Because every review hearing would not culminate in a foster care placement, then that would not implicate that inquiry provision. In other words, that the proceeding would start whenever the first hearing that might result in that would happen, I suppose, is another way of saying it. The earliest hearing that could implicate that or launch that proceeding.
Right. So I agree with that. I think throughout the foster care phase of the proceeding, or the foster care phase is one proceeding, and you would have one duty of inquiry and notice for that. But it seems to me, and maybe I'm interpreting it differently than other people, that once you then say, okay, we're done providing you with reunification services, parents, we're going to, look at another permanency option for this child, that is then a new proceeding, and that there is a separate and distinct duty of inquiry and notice that occurs when you move to that separate phase of the proceeding. And that's, if I'm reading that right, then it seems like that's a possibility for some disruption in a case that might have been going on for some time. But maybe I'm just reading that differently than other people.
Yeah, no, I understand your point, and I'm just sitting here thinking about like concrete hypotheticals in my mind where that would happen. I understand what you're saying. It's a good question.
Well, I know that it's not unusual at all in California for tribes to take a long, long time to respond to the notices. And of course they can respond at any time. But if they've properly received notice and delay in responding for 3 or 6 or whatever months, then the practice in California is to sort of treat that as something that has consequences in the case. That it is something that the court can consider when determining whether to transfer or to whatever. But it seems now that even if a tribe has properly received notice and they just did not respond to it, which is not uncommon here, and then they move to a different phase of the case and they again receive notice, at this point, it's like they can come in as though they never received notice earlier on in the case at the initial removal phase, and that's what's going to be a real change for California and seems to have the potential really to be disruptive of ongoing cases, and I just don't know whether that's how we're going to deal with that here.
Yeah, another thing that you mentioned, and Scott, I'm not sure if I don't want to put you on the spot, but if you remember this as well, the regulations talk about, like, for example, you mentioned, and good cause not to transfer. And if I remember right, the regulations explicitly say that, let's see, how do they say it?
Yeah, if the response is late,
yeah,
or if it's at advanced stage in the proceeding, if notice was provided late.
Yeah, that's right. That's what if notice was provided originally, that's right. Yeah.
Right, and then it's also if you, but you can't consider whether there was a prior proceeding where they didn't seek to transfer.
That's right.
So if you have the tribe participating in the foster care placement phase, and then it moves to the termination of parental rights phase of the case, and that foster care proceeding phase of the case could have been going on for 18 months, and then when you move to permanency, there's no consideration really of anything that's gone on during that period of time up to the termination of parental rights. I mean, that's less problematic, I think, for me than the whole idea of in an ongoing case that may have been going on for 18 months where everything has been done properly and inquiry has been complete and thorough and notice has been provided based on that. And either say, because it's also not unheard of that parents early on in a case will not disclose their Indian ancestry when they're asked, and then when it gets later on in a case, say when we move to the permanency planning or the termination of parental rights phase, and they're asked again about Indian ancestry, and they say, oh yeah, actually, that delay in claiming your Indian ancestry would have some consequences under California law here. But it seems that under the new guidelines, when you're moving to this new proceeding where there's a whole new duty of inquiry and notice, that the delay in divulging Native American ancestry at the earlier phase would have no consequences. And I want to know whether other people read it that way too, or whether...
Oh, this is a tough one. I have to say, one of the things when we launched this constituency group was that we all agreed that we were going to be a little experimental from time to time and just try out different structures to see if we could nail down things and keep tinkering and improving. So one thing that I'm sort of learning by watching this process unfold is that obviously these substantive questions have a lot of nuance, and there's a number of intelligent people all of us, I don't want to speak for myself, all of you are intelligent and see how thorny it is. I wonder going forward if we do this kind of troubleshooting method, if it would make sense to send the question out to the group earlier, like maybe a week early with the email, so that people could kind of play around with it before they came in, like that when I send out the reminder email, so that people could play around with it. That might be helpful. Just thinking in terms of process at this point. And if you've already said it, I apologize. Maybe you'll say it again. What are the consequences in California for the delay in bringing up Native ancestry late in the case?
Basically, it wouldn't be considered to have been a violation of ICWA, and you wouldn't be able to go back and undo what had happened. I think the main consequence would be that you wouldn't really be able to undo what had happened in the case. So to the extent that a child has been placed with and bonded with a non-Indian foster family, then that would be considered in determining permanency for the child.
Yeah, I guess what I'm getting hung up on, and maybe I'm just being thick-headed here, is if the state has complied with its requirement to do an ongoing inquiry and provide notice at the first, what we'll call the first proceeding, recognizing in California there's one filing, then at the second proceeding, if something new comes up, the part of the statute, the part of ICWA that says you can, the one of the parties of the tribe can, I forget which section it is. Let me see if I can bring it up here real quick. I think it's, let's see. Yeah, 25 U.S.C. 1914 says failure to provide proper notice is grounds for invalidating the court's action. So you could petition the court for it, like if you don't provide notice because you didn't get any on your inquiry, you didn't have reason to know, your initial inquiry, you didn't have reason to know that the kid could have been an Indian child pursuant to the act. But that only happens if you don't provide proper notice. I'm thinking myself backwards now, actually. I think I've convinced myself the other way. I guess my point is that having complied with ICWA up to that point, I'm not sure which part of the statute or regs actually say that you would undo work that's been done prior to knowing or having reason to know if you've, up to that point, applied ICWA correctly.
Well, I guess the thing that it seems to me is so if when you move to, so say you did everything correctly under your foster care proceeding, and there was no reason to know that it was an Indian child. You sent out notice to all these tribes, and some responded and some didn't, and whatever, and you make your determination. And based on that, you place the child in a non-Indian foster home, and you don't provide any culturally appropriate services, you don't provide active efforts, and you have a concurrent plan of adoption with then when you move to the termination of parental rights proceedings, this is where I see it potentially having a big impact in California. When you move to the termination of parental rights proceeding, as I look at it, there is a separate and distinct duty of inquiry and notice
Right.
at that phase. So you send out notice to all these same tribes that you noticed at the beginning of the foster care proceeding. And you are now telling them of the current posture of the case. And at this point, a tribe who never responded before responds and says, yes, they are actually an Indian child. And then the placement preferences apply afresh at the foster care, or at each stage of the proceedings, right, or at each different proceedings. So
right.
now you have a situation where you've had a child, the kind that we want to avoid, and that we always say you avoid by doing early and proper inquiry, where you have a child that's down a track of adoption by a non-Indian foster family, and that the agency and the court did nothing wrong. There was no ICWA violation. But as I read it now, in that case where the tribe comes in at the termination of parental rights proceeding, they have a right to say, at this point, we want, we want to change placement of the child. And that's where I see us getting a lot of pushback with our courts here, because I think there's no doubt that and the California appellate courts have been really good about saying where the agency or the court has screwed up, they can't rely on their own the consequences of their own actions in terms of bonding and attachment and all of that to keep a child in a non-compliant placement. But in the cases where tribes have been or parents have sort of not been proactive and have not provided information and have not responded, then our courts take a different view and say that that they've sort of waived their rights too.
Yeah, I'm following you, and as you're talking, I'm just reviewing the regs and the good cause to vary from the placement preferences section, and I don't, maybe I'm missing something, but I don't see where the regulations take issue with what you just said. So long as
as it wasn't in violation.
Yeah, exactly. So long as the initial placement, you can consider bonding and attachment so long as the initial placement was compliant. Yeah. It's only when it's non-compliant that it would become an issue. I think. I mean, I'm not special. I'm just looking at them, and kind of thinking through that way. Good. All right, so Amy asked another question. She says, can we clarify reason to know? I'll just read what she says. Can we clarify, quote, reason to know means that a parent has mentioned a tribe and you have sent notice, or do you send out notices to tribes even when a parent does not give mention about Native American ancestry? I'll take a crack at that, and I'm sure we can improve the answer. As I understand it, know or reason to know can be I take that to be pretty broad. In my own cases, when I litigate it, I mean, it's something like, I remember I had a case with an 8-year-old who he one day decided to point at his arm and his vein, and he said, "You see that blood? That's Navajo blood." I mean, up to that point, no one had any idea or any reason to know or think even that the case would be an ICWA case. And so, I raised that issue to the court, and then we had to sort of go down. We filled out the inquiry forms and so on to determine what counted as reason to know. So I guess in a weird way, the answer is like whether or not something counts as knowledge or reason to think that you have knowledge is a pretty like on the ground analysis that can emerge through just random comments made here and there. Got a few folks writing in the chat. So we're going to do about 3 more minutes on this question, by the way, and then we're going to move on to a second one. Yeah, that's actually a really good point too, Amy. I think one way that I've gotten around this one in court is, I don't want to say gotten around it. One way that I've tried to address this in court, one thing you could do is exactly what you just said. Like, let's just treat it like it's an ICWA case until you know that it's not. In other words, when the tribe says no. But that obviously is going to raise the problem that Ann has raised, which is what if you never hear from the tribe? In which case you'd always have to treat the case as an ICWA case. Another way to do it is, I just ask at each hearing. I ask the judge to make a finding, not necessarily that ICWA doesn't apply, but that there's no new evidence there's no reason, we don't know or have reason to know at this hearing that the child is an Indian child pursuant to the Act. Not so much that it's kind of a fine distinction, but not that the statute doesn't apply, but just the finding as to knowledge. The idea being that if the court does not find that we know or have reason to know, then the notice provision is not generated. Yeah, Scott, that's been my read of it. I'm not an agency attorney, I was a children's attorney, but if it came up, I would push on the agency and then try to do my own independent investigation to the extent that I could for the resources I had. So we're coming up against the clock on this one. I see a number of people are typing into the chat, so we'll go ahead and let people finish up their thoughts. Good. Yeah, and do you want to just say on the phone, I might be missing something on the reason to know.
Well, no, in California we have had a much broader interpretation of reason to know before, but when I looked at the regulations, I was a little concerned that they narrow it down. So I'm looking at 23107, which talks about
a court upon conducting
is reason to know. And so it's like an organization informs the court that the child is an Indian child, so that's more concrete. Or a participant in the proceeding informs the court that it has discovered information indicating that the child is an Indian child. I think in California and under the old regs it was maybe an Indian child, which is more and same, the child gives information that he or she is an Indian child. And then it talks about going down. So, resides on a reservation, informed that the child is or was a tribal ward of a tribal court, or the court is informed that either parent or the child possesses an identification card indicating membership in an Indian tribe. That's much more restrictive than we've ever applied here in California. Previously, all parents had to say was more or less, I think that I have Native American ancestry of some kind, and that would trigger the obligation to do full-blown inquiry and send out notice. And so I worry that the regulations are somewhat more narrow in what is considered reason to know now.
Yeah, that's a really good point, actually. And I brought those sections subsection C, sections 1 through 6. They're up on the left-hand corner of the screen now as well. Yeah, that's actually a really nice point, right? So I guess the way that would work is sort of somebody, like, let's just take my kid who says he's Navajo. That would, if I'm an agency attorney, that's going to have me look into and, do an investigation into the status of the child as an Indian child, the relationship, the heritage, the family tree, that kind of thing. But whether or not that triggers the notice provision is, I would need more than that, right? I would need one of these 6 things or something like these six things, which I agree with you, Ann. On my read, they definitely seem to be narrower than the way I've practiced in the past as well. So, All right, I'm going to jump over to, I don't know, Ann, hopefully that was a help. That was, for me, it was helpful, clarifying some
No,
things.
it was helpful. Yeah. Thanks.
Okay. Yeah, you bet. I'm going to jump over to question 2 now, and I see that there's a chat going on in the chat box. That chat will be preserved, so keep typing and don't worry as we move the screen around a little bit here. I'm going to review this question with the group, and then we'll see. I think we've hit on some of these questions, we've hit on some aspects of this question. It's sort of a notice version of what we just talked about, but let's make sure that we haven't left any stone unturned here. The question is, assuming that inquiry is done at the beginning of a case and there's reason to know, notice is sent to a number of tribes. Some tribes respond that the children are not eligible and others don't respond at all. The court makes a finding that ICWA doesn't apply. And when you get to the TPR proceeding, inquiry is done again, no new information is received. What if any tribes need to be noticed? Do you notice the tribes that responded to the children do you notice the tribes that responded the children were not eligible? I'm going to break these out. These are good questions. So it's related but not exactly the same question. Do you notice the tribes which never responded? And if the tribe now claims the child is an Indian child, what effect does that have on the case if the child had up to this time not been treated right? That one we kind of been wrestling with a little bit here. So let's try to take a crack at these. I'll set my timer for about 7 minutes. Let's try to take a crack at these first 3 questions, which are variations on, the notice and inquiry problem. Ann, is there anything else you want to add, or do you feel like that's fair? Those are fair enough?
No, I think that's it.
Okay, thanks. See a couple people typing in the chat here, so we'll give them a second. Take your time. Yeah, so essentially it's the TPR, no new information. You've provided notice and been compliant up to this point. Who needs to be noticed? I'm taking a second to look through the regs myself.
Yeah, what's jumping out to me about that question is, doesn't the rule go toward they were placed in a non-Indian home in violation of the Act, and if you didn't have a reason to know, were you really violating the Act, assuming due diligence?
Let's see. Yeah, I think in her hypo, though, you do have reason to know, and you do send notice. So I think the question is, do you send it again? Even though the court has made a finding that ICWA doesn't apply. It sure seems like the safe play. I know that's not that's not a very good lawyerly answer, but there's just so much to lose if you do a TPR and you don't have notice where the court determines later that there should have been. Scott, do you recall whether or not there was anything in the comments? I know there's like 500 and some pages of comments, but
no, I mean the only thing that's making me think of is just my argument, at least where the start of my argument would come from about this, is that regardless of the tribe responding and being involved, if you have a reason to know, then you have to follow ICWA. So there would have had to have been a good cause finding to deviate from the placement preferences.
Well, this is, Anne, and maybe we'll have to revisit our thing. So in California, the way our statute is set up is that you can have reason to know, and it can be based on something that's a lot less than what is set out in the regulations. So you don't have to have the child saying, I am an Indian child, and you don't have to have the parents having an identification card or anything like that. Obviously, if you had any of that stuff, if you had, a tribal membership card, the court makes a determination that ICWA applies. And ICWA applies regardless of whether the tribe responds. But generally in California, it's like, yeah, I think my, grandmother was Cherokee. That's what I heard. And you do all this inquiry and you get everybody's information, as much as you can, information back to great grandparents and, where everybody lived and maiden names and all that kind of stuff. That's the agency's obligation. And then they send out notice to the tribes, and if the tribes respond, no, the children are not eligible, obviously the court makes a determination based on that. But if the tribes never respond, under California law, it says if you've sent out notice and the notice is good and you have not received a determinative response from the tribes, then after 60 days, the court can make a determination that ICWA doesn't apply. And then they act on that basis. So that's what would be disruptive here, is if the court never received a response from a tribe, everything was done properly, they never received a response from the tribe, and make a determination that ICWA doesn't apply because no tribe has claimed the family or the child as an Indian child. And then when we get to termination of rights proceeding, they just send out all the same information again, and this time a tribe responds that yes, the child is an Indian child. So there wouldn't have ever been a violation of ICWA, at least not under California law, there wouldn't have been. But now, at the termination of parental rights stage, the case is at an entirely different posture, because now a case that had been ruled not to be an ICWA case throughout the foster care phase is now having to be evaluated as an ICWA case at the termination of parental rights. So that is definitely something that would be possible here in California. I don't know whether we're the only ones, but and that's what is troubling, although I think it's correct now that, we've talked through the placement preferences piece, that the court could say, oh, well, tribe, you had all of this information 18 months ago, and now the children have bonded and attached, and that was not a violation of ICWA. But the transfer to tribal court doesn't seem to have that same thing. So the tribe could come in and say, okay, we didn't respond to your earlier notice 18 months ago, but we are responding to this notice and we want to transfer the case to tribal court. And I just see a lot of pushback from our courts on that.
Yeah, I mean, underlying this, you're right. Underlying, I could just tell you California is not an exception to that fact pattern or to the pushback. I mean, we don't have to get too philosophical here, but there's sort of an underlying philosophical issue here about like how you conduct a best interest analysis, when it's appropriate, what are the variables that are included in it. I mean, whether or not, what we're trying to achieve by doing all of this. I mean, I get it. The underlying conversation is a more philosophical one. Though, in a weird way, despite this conversation and how thorny it can be, that it seems like the law piece is actually, in some ways, a little cleaner, or at least a little easier to navigate. It seems to me like in response to your question, I guess I'm thinking it out loud. What I get stuck on, I guess, is the court making a finding that ICWA doesn't apply. I don't think that would, under the regulations and the statute, I don't think that would trump, so to speak, the evidence that you got prior to that finding, that there is reason to know, just in your hypo. In other words, if you had reason to know initially and you complied with the notice provisions and you got some tribes that didn't respond and the court makes a finding that ICWA doesn't apply, my hunch, I don't want to say hunch, my opinion would be that your reason to know, you under the regulations you might not have reason to know, but I would still do another, I would take another go at finding out whether or not the child might be an Indian child, and then again provide notice at that TPR proceeding. Because it seems like you have to have carved out in the statute the opportunity for a late discovery, basically late discovery of ancestry.
Mhm. Yeah.
I know that's not a satisfying answer. Even when I say it out loud, I know it's not satisfying, but. Okay. All right. Well, it looks like there's just another chat. I'm sorry, were you going to say something? Okay. Looks like there's maybe one other person popping in from the chat. We have one more question that was raised, and this is, Scott, this was your question. Let me add, I'll read the question aloud, and then, Scott, you can add anything if you want. We might have worked our way around this one as well, so let me know kind of where you stand. He asked, do any of your states have additional proceedings, i.e. the regulations divide into dependency, neglect, and termination, but I think you can make a case that, for example, something like the temporary investigative authority in Montana is a proceeding that implicates actions that ICWA speaks to. How are you handling those types of hearings in your state? And Scott, just to, bring up Sherry's point from earlier, the way that we discussed it in the regulations was that a hearing, just go back to her language.
There are proceedings that the regulation spells out as at least your foster care placement, meaning legal foster care placement, and your TPR, but there's also more open language and emergency they treat differently. Okay, so those, I guess, the three really. Even though, in some states, California, there's one filing, basically, and I know that's true for some other states. There's a petition, and it's just amended to include a new goal, but in other places, it's like, here's a whole new petition, here's a whole new allegations. So, yeah, I was just curious about that I guess I really wish I just knew, how many places have how many proceedings, but I don't need to know that. I think I don't even need to know the answer, but I just think that's maybe a discussion question that if I were a CIP, my CIP committee might want to have about ICWA. Do we have a definition of what's a proceeding? Because I think it's relevant to know. I think we're given a minimum, but also a broad idea from the regs.
Great, thanks, Scott. So if in your state you're dealing with the definition of what counts as a proceeding in any way differently than the way we've talked about it so far, type that into the chat if you will. That'd be great. That could help us start to get kind of a national sense of how states are dealing with that. We'll set the timer for about 2 minutes for that one. Yeah, I'm looking at the definition here of child custody proceeding. Any action other than an emergency proceeding that may culminate in one of the following outcomes: foster care, termination, pre-adoptive, or adoptive placement. So it's really going to turn on that idea of an action, whether or not, for example, in Montana, the temporary investigative authority counts as an action that may culminate. I mean, I guess if what you're getting out of the temporary investigative authority, if what you're getting out of that is information that you could use to initiate an action that would result in one of those four outcomes, then yeah, you could at least make a case. And that's your point, right? Is that it can be read slightly broader.
Yeah. Yeah, it's the may culminate in these things. That's what I'm. Yeah.
Yeah.
Been there.
All right. Well, I'll tell you what. We'll leave that question kind of out there, and people can respond as they go. I don't know. It may be the case, Scott, that you're kind of one step ahead in terms of, or maybe the people on this call are one step ahead in terms of thinking about that one. Because the regulations, yeah, what counts as an action and what counts as culminating. I mean, sort of the old school lawyer in me thinks an action is a legal action, not necessarily an appointment of authority given by the court to an agency or an individual to engage in some kind of temporary investigation. To me, that seems more investigatory than it does to actually be an action, which to me requires some kind of filing. So if we were arguing in court, that would be my counter argument. Yeah, and Ann says this is something similar, right? That would be a pre-filing investigation by the agency. It may or may not result in the filing of the case, in which case it's not an action, so it wouldn't be a child custody proceeding, so it wouldn't trigger the ICWA stuff. Good. All right. Okay, cool. So we got about 19 minutes left. I'm not sure that we'll need the full 19 minutes, but let's bump over to, I wanted to ask question of the group here. So last time we had a meetup, let's say normally when we have a meetup, we've been following this 5C structure where every meeting self-selects to determine whether or not they want to be a creator, a carrier, a connector, or a consumer. And then the caretaker is the Center for Courts. And last time, Ann tossed out these really turned out to be kind of juicy red meat questions. So thanks for that, Ann, for us to work through. And then no one else selected to be a carrier or a connector. So it doesn't bother me at all, to be honest with you. I'm just curious why. And the reason why I'm asking this question is because I want to make sure that whatever structure we're doing, it's useful. I don't really care about, whether we have 8 Bs or 9 Cs or 3 As or whatever our roles are. What I care about is that the structure is useful to all of you. So if it's not, then I want to keep playing around with it and change it, which is one attempt, or one thing that we did today was kind of take a more troubleshooting approach as to opposed to the 5 Cs approach. So what I'd like you to do now is read through this somewhat long and winded and wordy poll and just respond to it, if you would. Give me a little feedback on sort of structurally how things are going and what your thinking is. If you feel like the question is which of the following best reflects why at the last meetup you didn't choose to be a creator, connector, or carrier. If none of those answers are really the answer, then type in whatever the answer would be in the bottom left-hand corner of the screen. You'll see it's sort of a short answer box. So you can just click other for your answer and then type in. And I see people responding already, but I'll give you about 90 seconds here to read through and respond. Thanks. Good, thanks. If you haven't voted, please do. it's super helpful in guiding this meetup. The idea is that it's useful, again, not that it takes a certain form. I'm glad to see, as a side note, that no one typed in a different answer. I sat here and tried to think of all the reasons why I personally wouldn't sign up. And so I tried to capture those in the multiple choice options. So it looks like I came at least close. So we'll take, we got about 30 more seconds on the clock. All right, so that's the time up for that one. So that's helpful. There's a variety of different answers there, so I have to sort of sift through that and figure out whether or not that what to do with that. Actually, I have one more question that's going to help me do that. So let's pop over to. All right, so it looks like our next meetup will be December 21st from 1 to 2:30 Eastern time. So just type that into the chat. That'll be the final. So if you want to jot that down, that'd be great. Of course, I'll send out a reminder a week early and let everybody know with a summary of what we've done here, and then let everyone know when the next meetup is. So the next thing, the second to last thing we have to do here is figure out what we're actually going to work on. So what I'm asking you to do now is respond to the poll on the right, which I just opened. And the question is, what ICWA-related project, program, or question are you wrestling with in your state that you'd like this group's help working on or troubleshooting? You just type that in. The idea is that, we'll kind of do a variation again on what we've done here today and troubleshoot a question. And what I'll do is send whatever we decide to work on, and it can be more than one thing, by the way. I'll send that out to the group a week early so people have a chance to think about it before we get together. And then I'll set up sort of little separate layouts for each one of the questions. So this is normally what we ask here is, what do you want to work on next? And we have a multiple choice poll where you can choose. So what I'm hoping here is that people will have a second or take the time to kind of think through their own jurisdiction, what they'd like the help of this group working on. So I'll set the poll for 3 minutes. I'm sorry, I set my timer for 3 minutes. If you could respond to the poll, that would be great. Thanks. All right, got a couple responses coming in, which is great. So we still got about a minute left. Take your time. Really, this is an opportunity, hopefully, to maximize the collective wisdom of the group and give everybody a chance to bring something to the table. One thing that I feel like maybe I haven't been as good as I could be at communicating to all of you is that, one way that we can use this group is to deliver information to each other. And we've done that in the past, and I think it's been effective. At least the data from the poll results have said that it has been. Another way that we can use it is to work through our own ICWAs, like whatever programs or projects that we're working on in our own state, do some peer-to-peer sharing and ask other folks what they're doing or what they would do if if I'm working on an ICWA project and let's say I have a tool that I'm not sure is working, I might share the tool, like a data collection tool for court observation or something like that. I might share the tool with everybody and say, hey, this is what we have. Our data seems weird. Is there something that we're doing wrong? What do you think about this tool? The idea being that the group can come together and help you troubleshoot your problems. I should probably come up with a different word besides troubleshoot, but I think you get what I'm getting at. We'll take about 10 more seconds here. Good. All right. So we see a couple things here. My hope is we would identify some commonality. One thing I see is a need for updated ICWA bench cards and an ICWA quick reference guide for the bench and parties. Those aren't exactly the same, but they're close. So I'm thinking what we'll do is literally since we have 4 responses and 2 of them are that, what we'll take up for our meeting next time is updated ICWA bench cards and quick reference guides. So the folks, I don't know who typed those answers in, but from my end, they're anonymous. So I'm wondering if those who mentioned those 2 things, could you maybe say something a little bit more about what you're looking for or what the need is? And if you could jot it down in the chat, that would be helpful as well. And then, I can include that information in the communications that I have with this group going forward so that people can go back into their own jurisdictions and see what they can scrounge up. I'm going to use my thinking cap and say that Kansas CIP and Gabriella are the two people since they're typing into the chat. So that's helpful.
Andy, this
Yeah.
is Gabriella. I just thought it might be
How you
quicker
doing?
for me to talk. Good. How are you?
I'm good, thanks.
So,
yeah, you bet. Go ahead and talk, and I'll type in your thoughts in the chat box.
Oh, okay. Thanks. Our judges wanted a quick reference guide that is no more than 2 pages long, front and back, 8.5 by 11, that doesn't include the legal citations, and that can give them a few questions that they can ask for each of the proceedings to make sure that they're in compliance with the Act and the new regulations. And something that we had pushed for is that it's not going to be just a bench card, because our bench cards and our bench book are not shareable material. So we wanted something that all parties could share, that the judges would be okay with them sharing as well. So that is what we're working on. We have a draft so far, and I would love to send it to everybody to get feedback on it. And we're going to be presenting it to our Board of Juvenile Court judges on December 9th.
Yeah, thanks, Gabriella. That's perfect. If you send that to us, that will be one of the 2 things that we tackle next week. I'm not sure I speak for everybody, but I'm going to go ahead and speak for everybody and say that that's something that we're willing to do and that this group exists to do. So just shoot me a copy of it, and we'll take it from there.
Okay. All right. Thank you.
You bet. Thank you.
So let me ask, reading what Kansas wrote, but it seems like the commonality here is trying to have something that's as short as possible. So what are really the requirements in it? Having tried to write about the regs in a short way, I don't think you're going to get everything that everybody would want to know in 2 pages. But I guess the question I have is, can you get enough so that people can do a C+ or B job? I don't think in 2 pages you can get everything to give people information to do an A+ job, but is that good enough? And would coming up with your elements that are going to go in your quick guide or bench card, coming up with your really short form elements or whatever you want to call them, would that work? Is Kansas CIP, is that done? Or somebody else? Would working through that on the call be helpful?
While Don's typing, I just see, I said earlier that there were 2 that were common in the responses, and the 2 were not. But actually, now looking back at it, I think that getting different groups together, tribes court, council, county council, agency on the same page about meaning of key terms and creating and facilitating a roundtable to address implementation and adherence to the new regs. I mean, there's definitely overlap there, right? Because if you're going to address implementation and adherence, then you're going to want to have some common understanding about the meaning of key terms and requirements. So that's another issue that's something else that we could take up next month. Don't spit your coffee out. Next month when we meet. So whoever wrote getting different groups together and working on implementation and adherence based on sort of common meaning of key terms, if there's something that you have in mind, if there's a method that you have in mind that you'd like more information on, or it's literally like a kind of an open-ended question, like what is everyone doing or how are they doing this? We could do either one of those, but maybe you could clarify in the chat for me. My question is this. Is your question that you'd like feedback on what you're already doing? Or is your question you're not sure what to do and you'd like to ask other folks what they're doing in order to get these different groups together, come to common understanding, and then address implementation and adherence? I see several folks are typing in the chat, which is helpful for me, by the way, because when I go back, I can review this. Yeah. Yeah. You had me laughing on that one, Scott. Take about 1 more minute to type your chat or your responses into the chat box, and then we'll close up the call. Great, thanks, Ann. That's helpful. That's a question that we can definitely bring to this group as well. So, all right, I see Amy is typing. Amy, I'm going to move the screen on you, but keep typing, and it'll capture your stuff in the chat box. It won't disappear. So normally we do an open space, but we'll skip the open space today just because we're short on time, and we've kind of had an open space today. Oh, yeah, I had all these great images I put together that I didn't show you. So that's all we have. On your way out the door, what I'd like you to do is respond to the poll in the upper right-hand corner and just kind of give me some feedback on what you thought about this troubleshooting model as opposed to the 5 C's model. Again, I'm not married to any of it. I just want it to be useful to you and your feedback. I mean, I literally look back on these polls and then make decisions based on the responses. So help guide me. And if you feel like this is a structure that we should try again, then that's totally fine. We'll give it another whirl. Hopefully it'll get a little better and a little smoother as we go forward. Anyway, for the rest, once you've responded to the poll, you're free to go. Thanks for all your time and your contributions today, everyone. And we will see you at the next meetup on the 21st.